Hello students, I am Radhika Chitkara and I work as a legal researcher with an NGO on gender and human rights. Now we open our module on human rights lawyering. Through the first phase, we discuss how human rights can be defended through law, and we take an overview of the experiences that human rights from across the globe has to offer to us. Through this lesson specifically, we will delve on the politics and practice of cause lawyering. We will endeavor to understand what cause lawyering or human rights lawyering is about and what its practice entails, and the manner in which it can effect change and political transformation. Human rights lawyering is a strategy by which rights of individuals and groups are championed through courts and litigation. This is distinct from championing human rights of individuals and groups through political processes, either through lobbying or through political mobilization or through public debate. So, for instance, when the rights to equality of women, of distinct racial and religious minorities, when the dignity of workers and the freedom of speech, etc., are defended through cases in courts, it's a facet of human rights lawyering. Through the course of this module, we will discuss two main questions. First, what is human rights lawyering? Within which we will discuss what is its role and its politics, what are its goals, what are the methods it adopts distinct from mainstream lawyering. And in the second part, we will discuss the impact that human rights lawyering has on political mobilization and transformation. For the first part, we discuss what is human rights lawyering. And we invoke Sarath and Shayangold's analysis of cause lawyers. So while human rights lawyering is known through distinct terminologies in different contexts and different jurisdictions, for instance, alternative lawyering, public interest lawyering, social justice lawyering, etc., Sarath and Shayangold prefer the term cause lawyering. First, because it gives a better history and a better background to litigation as a tool for attaining social justice. Human rights is a more recent phenomenon, whereas litigation has been used towards this end for a time when human rights was not as much in currency, but the causes that were being litigated were akin to the causes that are being litigated currently within the umbrella of human rights lawyering. But more importantly, Sarath and Shayangold state that cause lawyering is a term that is preferable to human rights lawyering because it captures the different nuances of the manner in which political lawyering of this kind can be conducted, which may or may not have a direct relationship with human rights. So we analyze this practice through three different axes to try and identify what is a cause lawyer. The first is through the relationship that the lawyer has with politics and ideology. The second, that the relationship the lawyer has with his or her client and professional ethics. And the third, the relationship that the lawyer has with themselves. Because is cause lawyering merely a question of self-identification? How does the lawyer identify himself or herself? So, for instance, is a lawyer espousing the cause of greater property rights of employers and corporations? A cause lawyer in the same sense that a lawyer who is advocating increased wages for labor. Is cause lawyering a question of self-identification? How is it that the lawyer identifies with himself or herself? Does the mere fact that the lawyer have an association with specific causes make the lawyer a human rights lawyer? Through this wide umbrella term and through the mode of self-identification, a lawyer advocating for greater rights of employers to strike down associations of its or of its workers will be a cause lawyer in the same sense who asks for greater rights of free association of trade unions as well. And this self-identification extends to the substance of the practice as well. Cause lawyering presents a nuanced and this self-identification extends to the substance of the practice as well. Is it necessary that a cause lawyer is only one who is in the defense of causes? So for instance, one who defends insurgents and terrorists in terrorism cases? Or can it also be one who prosecutes, such as public prosecutors, representing the state? There is a divided opinion on this, since public prosecutors are a part of the dominant state structure and they are not resisting the structures that they are not resisting existing political structures that the practice of politics expects. But in cases such as rape trials, in environmental protection cases, in corporate corruption cases, the public prosecutor is in fact occupying the position of the resistor, where he or she is representing the group that is voiceless and marginalized in front of groups that have greater power. So in a sense, it is possible to even view the public prosecutor as a cause lawyer. But what about situations in which laws make pro bono lawyering mandatory? So while these are not arising out of a self-identification of a lawyer, they nevertheless address a crucial question in politics and law, which is the access to justice question. By rendering their services pro bono, lawyers are able to bring the law and justice and legal institutions closer to those entities that would otherwise find it difficult to access these institutions. Thus, while the pro bono lawyer might not identify himself or herself as a cause lawyer, they are nevertheless serving a political end through their practice. So is it only the fact that a lawyer espouses political causes in his or her practice that is relevant? What is the relationship that the lawyer has with ideology, and what kind of ideology? Menkes and Meadow posit that a cause lawyer is necessarily one who espouses a redistribution of power and the construction of a just society. Lawyers that represent dominant structures within society, even as a political goal, are not to be called as cause lawyers or human rights lawyers. There, it is necessary for the practice of a cause lawyer to disrupt social, political and economic disparities. And through their practice, they encourage greater participation of voices in public policy and political mobilization. Michalowski specifically in fact states that cause lawyers are only those that have a dissident relationship with the state. And in doing so, he disqualifies the collectives of lawyers that the Cuban government sponsors to further the otherwise socialist individual or community claims. But as we've discussed briefly before, the state is not the only dominant authority structure. Even outside of the state exist power structures where power resides in entities other than the state. And in litigation, it is often the case, as with public prosecutors, that the state represents the voice of the marginalized. Along the third axis, we examine the role of the cause lawyer with clients. So since cause lawyers have a necessarily political practice where they are associated closely with one or several causes and are participating in an activity of mobilization and political transformation, a cause lawyer has a practice which is necessarily partisanal, which means, as a question of professional ethics, the lawyer is not neutral. Ethics for lawyers normally view the mainstream practice of a law and of a lawyer as a hired gun, in which the lawyer exists as a neutral slate, representing only the claims of the client that comes before them. Professional ethics of lawyers view the lawyer as a hired gun, where the lawyer has no entity or identity of his own and only represents the claim of the client who comes to him or her. Cause lawyers question this hired gun theory and the supposed neutrality of the legal practice in themselves. Even in their practice, they seek to expose the power disparities that exist within this paradigm of neutrality. They claim that neutrality obfuscates the power dynamics in practice which influence the access to justice of different communities. By having a partisanal practice associated with specific causes, they are able to bring equality and access to justice between different communities and between different claims. Therefore, their methodology necessarily requires them to favor a certain client or favor a certain cause over the others and dispense with neutrality. Which brings us to an important question of professional ethics, which is, do cause lawyers owe their primary responsibility to the client or to the cause? Advocates of cause-centered advocacy suggest that the interest of the cause must be given primacy, since the cause and its politics transcend individual cases. Individual cases, therefore, are only instruments of mobilization. Advocates of a client-centered lawyering, on the other hand, suggest that compromising the interests of the client is unethical and that client empowerment is important. The individual is as necessary to the practice of politics as the cause is. Whereas a new emerging theme in professional ethics delves into a moral dialogue. They suggest that litigation needs to be an exercise of moral dialogue between the lawyer and the client, where both together decide what the ends and means of the process must be. So, through the first part, we have noticed what ethics demand of a cause lawyer and how politics influences the practice of lawyering in itself. We now begin to investigate the question of what is the capacity of human rights lawyering and cause lawyering to effect real political transformation. Or in other words, what role do lawyers and the law play in altering the course of public policy? Through the rest of this lesson, we deploy Scheingold's study of cause lawyering in the USA and his framework of the myth of rights and the politics of rights. According to the notion of myth of rights, law is equally a part of social struggles and citizen consciousness as it is a figment of our imagination. Scheingold begs one to wonder, how active is the rhetoric of rights in the everyday consciousness of people? He analyzes the manner in which these instrument of rights differ between communities in order to effect justice. And this is because laws and legal institutions themselves respond differently to different communities. Therefore, the emancipatory potential that human rights offer to different communities is different and not universal. So Scheingold asks whether the culture and language of human rights transforms societies through litigation. The question therefore is there an inextricable link between law and politics? And he says that political and social transformation cannot be attained through a legal redressal founded on a narrow paradigm of rights and remedies alone. Because the law associates with politics in an altogether complex fashion. Litigation reduces complex questions of social and political injustice to narrow adversarial claims between two parties. Litigation also relies on pre-existing paradigms of rights and remedies, which are in themselves expressions of status quo and therefore constrained as vehicles for transformation. So where is the dichotomy? This leads to a dichotomy. The law and rights are viewed as a tool for transformation in public consciousness, but actual transformation requires the trickle down of the rights discourse into the real experiences of the people. And this is the myth of rights, where rights become an ideology instead of a lived experience. The real struggle actually lies in the politics of rights. The politics of rights, in other words, is the form of political activity which is made possible by the presence of rights. So, politics of rights reads the manner in which the myth of rights interacts with public institutions and public consciousness. He states that the myth of rights as an ideology should structure public institutions and therefore determine their rules, their conduct and their behavior. But Scheingold found that American institutions are not consistently or regularly responsive to the myth of rights. To stress the point further, we analyze the landmark decision of Brown versus Board of Education. Now, this was a landmark US Supreme Court decision which held that racial segregation in schools is patently unconstitutional. Now, the decision in Brown had a domino effect on the political rights of African Americans. Cause lawyers, with the aid of Brown as precedent, were able to secure a gamut of other rights for African Americans in the American society. They were able to secure non-discrimination in local schools. They were able to secure the right to vote for blacks. They were able to secure the right to public accommodation and fair housing. And through all of this cause litigation in courts, in their advocacy, these cause lawyers were radical in their methodology also. They rejected established legal doctrines in their work. They rejected restricted covenants, which justified white populations to limit the transfer of their property within the race and prevented it from transferring to African Americans. They also were able to reject the established doctrine of separate but equal, by which formally African Americans were held to be equal in the eyes of law, but were nevertheless accorded separate treatment, which in practice was greatly discriminatory and impacted their living standards and dignity much differently than whites. So the decision in Brown also led to the establishment of the United States Commission on Civil Rights and the Equal Employment Opportunity Commission. In fact, Brown was held to be so significant that it is credited with sparking the civil rights movement in the United States itself. triggering significant cause lawyering on race, gender, ethnicity, environment, etc. So we notice that within courts there was an entire there were weighty decisions by which it appeared as if African Americans were now finally making the strides towards equality with the white population in the United States. That the rights as an ideology were functioning because they were supposedly influencing judicial decisions and public institutions. But what were the politics of rights in Brown? How much of social transformation and political consciousness was it able to change? Authors have analyzed how the quality of education of African American children till today continues to be abysmal. And why is that? Because litigation for the rights of African Americans in courts championed integration for the sake of integration alone. It neglected the core concern that lay at the base of this issue, which was an equality of opportunity for African American children in schools and in employment subsequently. Orfield, in fact, analyzes how schools in the USA were now more racially desegregated than they were in 1954. And why? This was because due to litigation on anti-segregation, segregation itself was viewed very narrowly due to the modus operandi of the litigation. Therefore, only when it operated patently was it held to be unconstitutional. However, racial prejudices are not racial prejudices, just like any other prejudice, is not something that gets eliminated by merely holding it unconstitutional. Prejudice begins to operate latently, and while operating latently, it was not recognized as discriminatory. And so, even as discrimination existed in practice, the white population was nevertheless convinced that it was entirely annihilated because it was held to be unconstitutional. So, for instance, there was a case which tested the need for school buses for African American neighborhoods and whether they were necessary at all or not. The US Supreme Court held that they were not necessary, thereby consequently leading to de facto segregation in schools. Because segregation in residences continued to persist. So if buses are not available to transport children from African American neighborhoods to the schools that are set up in white neighborhoods, the school will nevertheless be populated by the privileged class alone. There is yet another facet of human rights lawyering and championing rights through the mode of litigation, which is that often litigation is unable to redistribute power between disadvantaged groups, since rights are advocated as a narrow adversarial claim between two parties, the advantaged and the disadvantaged. Consequently, disadvantaged groups fight inter se for resources. For instance, workers inflicted by asbestosis claim compensation from corporations. Corporations claim bankruptcy, which hampers the interests of the present workers. Similarly, in employment, women fighting for maternity benefits are in conflict with women fighting for abortion rights. So it divides the civil rights community in itself. The case of Ho versus San Francisco Unified School District exemplifies the point further. This is a fight between two racial minority groups in USA for representation in public schools post-Brown. And this typifies the disjunct between critical race theory and political lawyering practices. First, it challenges the notion that racial desegregation practices are for the benefit of racial minorities. Second, it exemplifies the dissonance between legal justice through the rights paradigm and racial justice that is actively experienced by the minorities themselves. What is the case about? In Ho versus San Francisco Unified School District, the minority community of Chinese Americans are seeking greater representation in schools in USA at the cost of the seats that would otherwise be used by African American children. In their arguments, they are claiming that Chinese American citizens are more meritorious, have a better track record in academics than African American children do, and are therefore more entitled to participation in public schools than African American children. So this presents the dissonance at three levels. First, the plaintiffs in Ho ignore the historical relationship that exists between law, culture and racial oppression by articulating their claims in the language of less worthy and more worthy. Second, they deploy the neoconservative distortion of anti-discrimination rhetoric to undermine the historical and social purposes of anti-discrimination in itself. Ironically, this was first birthed by the civil liberties litigation by the African Americans. And third and most importantly, the plaintiffs view racial discrimination through a limited prism of victim-perpetrator, white on black dynamic, failing to account for the intricate matrices within which discrimination operates across grids. So Scheingold's solution to this is in the politics of rights. He argues that rights should be viewed not as ends in themselves, but as resources. The end objective is actually redistribution of power. Rights as resources in litigation do not directly lead to redistribution of power, but they do so only when they are used for political mobilization outside courtrooms. Therefore, it was not really Brown versus Board of Education, the US Supreme Court decision that triggered the civil rights movement in USA, but the response with which Brown was received in the streets and in the homes and in everyday politics. So what is the role of lawyering for human rights, or what is the role of cause lawyering? It triggers mobilization by bringing issues to light. It initiates public debate and conversations. It grants legitimacy to claims of the disadvantaged. And in doing so, it is cause lawyering or human rights lawyering is a part of the story of overall mobilization. It is effective only when issues are ripe for discussion. So, students, to summarize, over the course of this module, we have addressed two major questions. One, what is a cause lawyer? What are their politics? What are their practices? What are their methods? And two, we have discussed what is the role of cause lawyering or human rights lawyering in overall political transformation. As for the first, we analyzed a cause lawyer along three axes. First, of the lawyer's relationship with himself or herself, reflected in the substance of their practice. Second, the relationship that the lawyer shares with politics and ideology. And third, that the relationship the lawyer shares with clients and professional ethics. Significantly, we delved on professional ethics and methodologies of a cause lawyer. Is the primary responsibility of the cause lawyer to human rights, or is the primary responsibility of the lawyer to the individual litigant who presents himself or herself before the lawyer? We recognize that a growing stream of literature encourages the use of moral dialogue between the lawyer and the client, by which both can deliberate and equally participate in deciding what the ends and means of the litigation should be. But more importantly, through the second part, we delved on the question of how far human rights lawyering can affect transformation politically and socially. We did this through the lens of Scheingold's study of cause lawyering in USA and his articulation of the myth of rights and the politics of rights. According to Scheingold, myth of rights represents rights as an ideology which can be used for the articulation of claims, but which does not necessarily percolate into shaping the actions of institutions and state bodies. It is the real political change lies in the politics of rights, by which rights as an ideology is able to percolate down to the public consciousness and public institutions. We analyzed the role of human rights lawyering through the paradigm of myth and politics of rights, specifically in the case of Brown versus Board of Education, where it would appear that the litigation before the US Supreme Court might have sparked off an entire civil rights era in the United States of America. But real transformation was not as was portrayed by the judgments in themselves. That political transformation was still at bay because Brown did not necessarily lead to the correct politics of rights. For instance, the case of Ho versus San Francisco Unified School District exemplifies this point further, where the litigation obfuscates the power relationships that underlie racial discrimination in itself, and how litigation is unable to solve that problem because it views rights merely as adversarial claims between two parties, instead of looking at the manner in which power and deprivation exists to different extents and in different ways along different matrices.